We are live.
Good morning. It's March 12th. We're taking up S322. We have Ledge Council here with us. We recently provided us with a memo regarding S322, and it's on our website. And they'll be providing some additional perspective on this level. So, floor is yours. Thank you.
Well, good morning, Committee. Tucker Anderson, Legislative Council, here with my GovOps partner.
Thank you very much for having us.
And we're here this morning to illustrate some of the constitutional framework around S322. In specific, we're going to talk about the two largest components of the bill. First, the exercise of legislative authority under what is, if not commonly, frequently referred to as the reserved power under two sections of the Vermont Constitution. And then at the end, discuss the First Amendment parameters around regulating corporate spending on ballot issue and election activities. I do have some tabs ready to go through for the committee, if that is okay, so that we can focus in on some of the language. I'm going to start from the top by discussing the source of authority for the General Assembly's power over corporations. I'll walk you through some of the history around the reserved power. And then at the end, we'll talk about what some of the limitations of the exercise of that authority are. And I was actually really hoping that Anthony and Tom Moore would be able to present first so that they could give you the introduction to the concept before I started doing the legal analysis, but I will try my best to kind of frame what is happening here. Many of you on this committee already have facility with the General Assembly's chartering authority in various contexts. Two of you, current and former members of Senate Government Operations, are familiar with the General Assembly's authority over municipal corporations and the ability to charter the political subdivisions of the state. That is an exercise of the supreme lawmaking authority. You have heard me go on and on ad nauseum in the most boring way about Dillon's rule and the constitutional authority the General Assembly has to dictate the powers of municipal corporations. But there is a component of those same constitutional provisions, and I have referred to this in the past, that deals with non-governmental corporations. That is the power that is proposed to be exercised under S322, the power to determine the corporate powers that any organization organized under the general laws of the state can exercise. So we always start from the top. The legislative powers. This is the source of authority here. And if I can move some of the Zoom controls around. It's right here. Part of the supreme legislative authority is the power to grant charters of incorporation. This is subject to limitations that are articulated in Section 69 of the Vermont Constitution. Prior to 1913, this was just the general authority to grant charters of incorporation to any type of corporation. Section 69 was added to the Vermont Constitution to specifically limit the exercise of that power. And it has three major components. So first, it states that no charter of incorporation shall be granted, extended, changed, or amended by special law. That means individual acts of the General Assembly relating to a single corporation or a small group of corporations, not general law that is applicable to all of them. So there's your standard rule. Special laws are prohibited for chartering corporations. There is an exception for municipal, charitable, educational, penal, or reformatory corporations. That is where the full Dillon's rule, often referred to as pure Dillon's rule authority of the state, comes into play, because you can use any type of act to determine the powers of municipal corporations, and you can charter individual cities, towns, villages, water districts, waste districts, whatever form of government you can imagine, you can charter it and empower it. Important clause here. those corporations, those governmental ones, as are to be and remain under the patronage or control of the state. Language that generally relates to a position of trusteeship and originates from some very interesting early 19th century cases that I believe all of the witnesses you will hear on this morning are going to discuss. But, important caveat coming up, the General Assembly shall provide by general laws for the organization of all corporations hereafter to be created. So, on the one hand, you have your governmental corporations, you can charter them individually. On the other hand, all other corporations have to be organized under general laws. You pass general laws that are universally applicable to corporations that are organized under those laws. All of those general laws that are passed may be altered or from time to time may be repealed. That little highlighted clause, sentence right at the end of section 69, is the reserved power. You may be asking yourself, because you have been here for a long time, you've heard the charter spiel, you're familiar with the supreme lawmaking authority. Why does the Constitution contain a sentence that reserves the authority of the General Assembly to do what it's already empowered to do? Well, to answer that question, we have to look at a culprit. And the culprit is Justice Story, specifically a concurring opinion that he wrote in the early 19th century in a case called Dartmouth College, the trustees of Dartmouth College, v. Woodward. And in that case, the Supreme Court was analyzing 3 acts passed by the New Hampshire legislature that amended the charter of Dartmouth College. And primarily they were looking at an act that altered the board of trustees that had control over the college, adding public members. So they review that. They are looking at a charter that predates the existence of the state of New Hampshire. It's a charter that was issued by the Crown to individual incorporators in the United States, in particular, Dr. Wheelock, to provide education to people in the New Hampshire grants at the time. The court ultimately looks at that charter. It was ratified when New Hampshire became a state as an agreement between the governmental power, in this case the state, formerly the king, and the incorporators. And that the terms of that agreement, specifically in the composition of the board of trustees that control the corporation, could not be altered unless, just like any other contract, both parties agreed to the changes. Because of that, the charter itself is inherently a contract between the parties that is protected by the United States Constitution. This tees up a serious conflict, constitutional conflict, the sovereignty of the United States and the constitutional guarantees that are afforded to every single citizen, and then the sovereign powers of the state, which includes the authority to create corporations and determine their powers. So Justice Story proposes the following. If the legislature mean to claim such an authority, the authority to, from time to time, unilaterally alter the terms of a charter, it must be reserved in the grant. And I could go so much deeper into the grants here because, as it turns out, some of the cases that precede this, the grants that were given were glebe lands. I don't know if that rings a bell for any of the GovOps people, how many times I've talked about the colonial glebe lands in committee, but
How do you spell that word?
GLEB. It is land that is owned perpetually by the state that is leased for indefinite periods to named individuals that either benefit the Society for the Propagation of the Gospel in Foreign Parts, the Episcopalian Diocese, the church in the town where the glebe lands are located, or the school in the town where the glebe lands are located. And to this day, there are still colonial glebe lands that persist within the state of Vermont, the state of Virginia, and I can't remember which of the Carolinas, but a Carolina has some glebe lands too. I didn't track it through this book. As a result of that proposal, that the states could reserve in the agreement between the parties the power to exercise legislative authority to change the charter. Nearly every state has amended the constitution of the state to add this reserved power so that for all chartering acts in the future, the power is already reserved to make changes, and it resolves the conflict between the contracts clause of the United States Constitution and the state legislative authority to issue, amend, and repeal charters. But that's not the end of the story. And the reason it's not the end of the story is that because of the way that Dartmouth was written and the understanding of state sovereignty at the time, which was derived from an omnipotent British Parliament, that it was not restrained by written constitutions, state legislators started acting a little bit out of form. They started altering charters in ways that triggered other constitutional issues, because the belief was that there was this God's hand power over the existence of corporations that perhaps was extra constitutional. But as the court clarified over the years, not only is there not an extra constitutional authority to alter or repeal the charters of corporations, but in cases where the corporation has simply organized under the general law, the court has revisited its view of that and found that there is no contract in some of these cases where the corporations are organized under general law. Ultimately, the exercise of this authority, specifically the authority of the General Assembly of Vermont under Section 6 and 69 of the Vermont Constitution, is limited by guarantees found in the Vermont Constitution and the United States Constitution. The easiest way that I can frame this for you is the reserved power is as expansive as the lawmaking authority, but it is still subordinated to the guarantees of the Constitution. Section 69 does not relieve the General Assembly of the obligation of issuing laws that are constitutionally compliant. You still have to comply with the Constitution on both sides of the ledger. So the memo's exhaustive, and I apologize for how many footnotes there are. I got a little too excited about the research because it's an element of this part of the Constitution that I was completely unfamiliar with, despite the fact that I work with it all the time. So first, the General Assembly can't use the charter authority to restrict the exercise of its paramount legislative powers. That's not the issue here, but I wanted to make sure that you understood the scope of the power that's involved.
Wait, they can or they cannot use?
They cannot. So an example of where this became an issue is there were states that had in an individual charter granted to a corporation fixed a tax rate, as an example, or given a railroad, they're all railroads in these cases, with the exception of the ones that are dams. They give a railroad a tax exemption that is later changed. The court then has to review whether revoking the franchise or privilege, essentially having a general law that applies a higher or different tax than what is contained in the charter, is in itself a takings, or perhaps triggers due process issues. And in many of these cases, the Supreme Court has said that the General Assembly and other state legislatures cannot bind future assemblies through a charter. So the privileges that are granted can't bind the exercise of the police power, eminent domain authority. The paramount powers of the General Assembly cannot be bound and restricted by a corporate charter. So that's one side of the ledger, and I have gone through the cases and the footnotes if you want to see some of the specific examples. But the paramount power of the legislature, and I quoted this the other day in Senate GovOps, Salus Populi et Suprema Lex. The health and safety of the people is the supreme law, right? That's the police power. Cannot be fettered by a corporate president. Is there a part of that I need to learn?
Yeah, just say it all again, because I don't fully understand what you said.
The General Assembly can't use a chartering act to restrict its constitutional powers. So it's another conflict of law analysis where the supreme power of the legislature is not bound by an individual act. And it follows a principle that any one of those acts can be amended in the future. And in particular cases, to protect the health and safety of people, to exercise the police power.
Sound good.
The second half of this, the other side of the ledger, is that state legislatures cannot use the chartering power to remove corporations or third parties that rely on corporation from the guarantees of the United States Constitution. The general rule, to frame it for you, is that yes, there is this expansive power over corporations. The General Assembly has the authority to determine the powers of those corporations. But the outer limits of that legislative authority is the United States Constitution and those rights that are guaranteed for corporations in this specific case. Would you like me to go through the exhaustive analysis?
This one is a bit more straightforward, so I mean, unless anybody else.
So I will flag for the committee that in the history of analysis of the reserve power and its potential impacts on corporate rights, courts have reviewed legislative acts, chartering acts for compliance with the Contracts Clause, the Establishment Clause of the First Amendment, due process and equal protection rights under the 14th Amendment, the Takings Clause of the Fifth Amendment, and access to federal courts under the Judiciary article and the 14th Amendment. And on that last part, we'll talk very briefly about the potential that you could, and I haven't analyzed it here, tiptoe into the realm of unconstitutional conditions, which is a later doctrine of law developed mostly in the middle and second half of the 20th century that might also apply here and was initially discussed in the case cited in footnote 33 regarding access to federal courts and the judiciary under the Judiciary article and 14th Amendment. That was Turali-Burke. An important decision because it also covers foreign corporations, not just those corporations that are chartered within the state. Tees up ultimately that the survivability of a proposal depends on the constitutional analysis and the rights that are involved. And in S322, the rights that are involved fall under First Amendment scrutiny, which is what Tim is going to have with the law.
Yeah, the record to that one of the council. I'm going to be kind of bringing us into somewhat recent history of modern campaign finance law, starting in the 70s, kind of running through some of the seminal cases and really bringing us to discussion of the land water case, Citizens United. And throughout that, this analysis, really, I should say, an account-line analysis in terms of First Amendment protections and really, yeah. And I just want to initially note that there's much information included in footnotes and also appendix, particular concentrating on Citizens United. I provided a summary of that case and just pause for the offer. Page breaks in there. It's a little bit longer. Go through that. So, just kind of orient us generally on this topic. The U.S. Supreme Court has made it abundantly clear that corporations have a protected right to free speech via the First and 14th Amendments, and that speech in elections entails contributing or expending money, and therefore corporations have a right to spend money in elections. But while these rights are not absolute, political speech simply cannot be banned or restricted as a categorical matter. Courts have historically dismantled federal and state efforts to control corporate politics and electioneering when those regulations are seen to be increasingly infringing on those First Amendment rights. So let me start first with just kind of acting or stage of what First Amendment really are. So the First Amendment provides protection from governmental infringements, the right to freedom of speech. And we probably aware that the First Amendment is applied to the states of the 14th Amendment, but it should sound familiar because of how it states that the government shall make no law abridging freedom of speech or of the press or the right of the people peaceably to assemble and to petition government for redress of grievances. It should be said that expressly, we have the right of freedom mentioned there. Freedom of association is an implied right and is really has wide and detailed treatment by various common laws. The protection from governmental interference is broadly and literally applies to what people can say. Term speech, and also how people can come together and speak with a shared and amplified voice to act in furthering their shared goals and association. And then it should be noted that when we have speech and association occurring in the context of political speech, the courts consider this a enhanced right almost, but really fundamental to the operation of our democracy. And so these core political speech rights, it's important to note that they can take the form of literal speech or more figurative or symbolic expressions or that can be provided to the candidate via contribution or the expending of money independently of the candidate too. And similarly, the right of political association is not only affecting or sort of affiliated with each other, but also the ability to come together and present an enhanced advocacy by that group association with numbers and resources. So next we turn to the idea that corporations have the right to freedom of speech, the U.S. Constitution, the able review process, association rights. So the due process rights of the U.S. Constitution is found in the 14th Amendment, and this ensures to provide due process of law to a person before depriving the person of life, liberty, and property. The court common law really takes up an analysis of that liberty interest for the most part. Of stress that. So let me rephrase this. The U.S. Supreme Court has held that freedom of speech and other freedoms encompassed by the First Amendment also viewed as fundamental components of liberty safeguarded by the due process clause. That it's been set up for almost a century that corporation persons within the meaning of the 14th Amendment. And then we also turn to associational rights, or an alternative form of which these protections of free speech are granted to corporations. And we all know that certainly individuals are an association. But of course, that associational rights are derived from the rights of individuals. And the ability and opportunity to combine with others to advance the powerful practical means of ensuring the perpetuation of freedoms of the First Amendment. And those that again to the individuals, to individuals against government. And the third point, spending is protected and sometimes considered speech. And it is, courts discussed in Buckley and successors, especially in Citizens United, that just as a modern feature of campaigning and electioneering in general, that various forms of speech really all entail some cost, whether that be handing out, anything as small as opinions, ads, those cost money to produce. Mass media, monitoring require substantial investments to be made in TV, radio ads, internet ads, et cetera, et cetera. But I think it's important to remember how corporations, the ways in which they spend money, they are treated somewhat differently. They will certainly come up in conversations about campaign finance in general. So the first would be contributions. The second would be independent expenditures. And those of you who have not been on government operations center and down the hall will know that we have detailed all of this in Title 17, where we have our elections. And contribution is a payment that is made to a specific political campaign, party, or political action committee as a PAC, which may be later expended in a coordinated fashion. And these are capped under state law and must be permitted. Generally speaking, independent expenditure lacks coordination with candidate party is made by the corporation or its political actions. That's a PAC. So the access to donation.
Yeah, and just for my explanation here, what constitutes a corporation and how broad is that?
That's a great question. And maybe I can kick it over to my colleague Rick if I can.
Oh, go ahead. I didn't mean to interrupt.
Oh, no, it's quite okay. Corporations and the way the law understands them, it's rather broad. So, especially in the context of free speech, we courts often consider the press. They consider political parties. They consider unions. They consider nonprofit advocacy, nonprofit ideological corporations, as well as for-profit corporations. In the sense, sense of an artificial person. Although it's good to remember that, and especially in the Citizens United decision, the Supreme Court really just used it as a different type of association. And because it's just an association, it's association of individuals for which the rights of those individuals and can be enacted by the conglomerate. In fact, all of them.
I can bring it back to the basic rules and maybe nerd it a little bit if that's for so corporation, right?
Yes.
The very first part of that corp, body. In its most basic form, it is a group of individuals or in a sole proprietorship, one individual that makes a body and law. You make that artificial person that stands in front of the incorporator, the natural person, and is vested with rights from that incorporator. So you and I wanted to start a corporation. We would, under the general laws of the state of Vermont, determine what type of organization we wanted to be and what the purpose of our organization is. We would register and create that artificial person, that body, in law. And then we would vest it with rights. Typically, that means giving it money or profit. In its most ancient form, the corporation was used to protect the church. It is grown out of the division between ecclesiastical law and civil law. Churches took a long time to build in order to avoid perpetual succession, generations owning the property and the church that's being built over and over, 300 years of passing off the church. You create an organization that lives forever, that will hold property for you so that you don't have to be susceptible to the law. And at the time, it was susceptible to invasion by the tyrannical force, which was the king.
Thanks.
This is a timekeeping note, open up stop at 10:45 so we can give Anthony.
Sure. Yeah, no, that's yeah. So, just kind of recapping that courts have gone out of their way to explicitly state that spending money is a form of speech, and that corporations spend money and contributions for independent expenditures. And the important nexus to understand here is that what the courts really care about is the level of coordination between outside money and campaign. And this is based on proper governmental interests of corruption, the appearance of corruption. So contribution, because it's coordinated with the campaign between a corporation and a campaign or a campaign or a political party, that's going to basically, to an extent, be regulatable, however, not being prohibited. But when we look at independent expenditure, that is something that there's supposed to be province requires that no coordination between the corporation and the campaign. Then there's no quid pro quo, there's no corruption, there's no reports, and therefore there's no worry about that. So without that significant governmental interest, it would be an improper infringement upon the First Amendment rights of the corporation, therefore not regulatable. So if contributions can be to an extent, independent expenditures cannot be prohibited in any sense. So again, just kind of to go over that syllogism, we have corporations have a protected right to speech. Speech in elections entails contributing or spending money, and therefore corporations have a right to spend money in elections. That's the logical cycle there. And again, although these rights are not absolute, the courts have historically taken one bite at a time or evaluated the whole in some situations, state and federal efforts to regulate how corporations spend money and electioneering efforts or general. And so in page 11, we kind of have a rundown of the various levels of scrutiny that is the legal tests that are applied here. And just to know that political speech is under strict, that's the highest. And then we have board disclosure and right of association. We have exacting, which is very active as well. And I just want that out to say is that the court is going to take a look at any of these issues with going to apply the most rigor, most scrutiny to any regulation that comes forward on this topic when it comes to freedom of speech, even if it's in the context of not individual but a corporate or official person or association. And
to summarize both parts of the memo and give you an idea of the constitutional framework of the exercising this power through the reserved power or the general authority of the General Assembly to enact terms does not save it from the constitutional scrutiny that will be applied to any other form of legislation that restricts, limits, or revokes these corporate speech rights. It's going to be subject to the same analysis. This isn't the saving for. One thing that we do not touch upon just because there is no supporting law for us to give you objective analysis is that part of the proposal here is that there is a meaningful distinction between powers and rights. That there's a division between the powers of the corporation and the rights that are guaranteed on the first. We could not find any source of law to support the division between power, spend money in elections, and those rights that are protected in other cases that Tim just discussed. So we didn't cover it in the wanted to note that at the end. I also wanted to say we're not judges. As far as I know, this committee has not nominated and confirmed Tim and I to sit on any high court. It'd be a wonderful surprise if that happened this morning, but I don't think it's the case.
I
So-
make that motion?
We have to rely on what we see in the cases, try to present it to you in an objective, nonpartisan fashion. That's what we're trying to do this morning, and we don't have a crystal ball. But we do have one interesting piece of dicta that I wanted to share with you from one of the cases that Tim covered. This First National Bank versus Hawaii. To tee up what I'm about to cover very briefly, because again, not binding, not part of the holding. Doesn't matter all that much, but it gives you an idea of the Supreme Court's view of what is happening in S322. Hawaii dealt with federally chartered banks challenging a Massachusetts law that restricted spending on elections. The Attorney General in Massachusetts, as this was being challenged, raised the argument, hey, the Commonwealth of Massachusetts has supreme authority over chartered corporations. We're exercising the reserve power. Ultimately, that really didn't get taken up by the Massachusetts courts because these were federally chartered banks outside the scope of that reserve power to begin with. But the US Supreme Court took note of that argument. And in a footnote in their decision, they discussed that that really is not a solid foundation for limiting spending in this manner. And specifically, they noted that the court below recognized that such an extreme position could not be reconciled with many decisions holding state laws invalid under the 14th Amendment when they infringe protected speech by corporate bodies. They listed the exhaustive number of cases that have held that. Most of them deal with media organizations, which are also corporations, as Tim noted earlier. And then they went on to talk about many of the other rights that have been found and conferred to corporations by other US Supreme Court decisions. All of which is to say that the court's view of this argument at the time, this is in the 1970s, was that this was not a solid foundation for restricting First Amendment rights. That's all that I have, unless Tim has more of our top hat cane show for you this morning.
But I would just encourage community members to take their time going through the memorandum and the appendices there. And let us know if you have any questions. We'll always happy to respond to testimony or written form, whatever the convenience.
And it is actually, despite how beige Tim and I made it this morning, an extremely fascinating era of history that this developed out of. It is a very interesting legal and philosophical endeavor to kind of navigate some of the arguments supporting S322. It's definitely worth your time because it lances the heart of the powers that you all work with every single day. I could name a bill in each of your other committees right now that deals with this exercise of authority by the General Assembly. Thank you very much.
Thank you.
Thank you. Well, actually, committee, any questions?
I just got a quick one. There's something here on page 1 of your memorandum. Under B, the last line, this is the opinion of the alleged council as far as legislation in power of the corporation likely violates the First Amendment of the United States Constitution.
Yes. And we deal in lightness. So we looked at the absolute weight of authority related to the proposal on the table right now. And the determination is that likely, more than likely, is what we're here. We didn't touch upon all of the constitutional issues that also come up in S322. There are a few things we could flag for you about equal protection, particularly some of the carve-outs. And one of the penalties in there, and Senator Baruth brought this up when the bill first came up for a long through. One of the penalties might chafe against the unconstitutional fines and penalties provisions of the U.S. Constitution because it could be rather large. The example that Senator Baruth gave is a $1 million expenditure could have a $1 million penalty associated with it based on how it's currently structured.
Thank you. So next we'll have Anthony. 3 minutes ahead. Thank you for your patience, flexibility, and please introduce yourself and floor is yours.
Appreciate the time. Thank you, committee. For the record, my name is Anthony Irapino. I am an attorney and also a registered lobbyist for the Vermont Public Interest Research Group. Also happen to be a longtime sustaining member of that organization. I agree with the work that they do, and that includes S322. I am also not a judge, but I have been practicing both corporate law and campaign finance law in the state of Vermont for nearly 15 years. In that practice, represented a number of corporations and counseled them in terms of their ability to engage or not engage in political speech, as well as represented a major political party. I want to make clear that my views here today are not on behalf of any client other than the party. But if I were a judge, I would respectfully reach a different conclusion than your legislative counsel has reached. And I'll get into that in my testimony. But we just heard a lot about some pretty dry case law, and I want to bring us back to like why you're even thinking about this to begin with. Because the consideration of S322 comes at a moment in our history where American democracy and the integrity of our political process, which was once the envy of nations across the world, has never been more imperiled. And there are many causes of this peril, but most can be summarized by a quote from the Watergate era film, All the President's Men. And that famous quote is, "Follow the money." Recent public opinion polling confirms that nearly 8 in 10 Americans, that's 79%, agreed that large independent expenditures, the technical name for political ads that are not coordinated with the candidate, by wealthy donors and corporations in elections give rise to corruption or the appearance of corruption. This included 84% of Democrats, 74% of Republicans, and 79% of independents. And relatedly, more than 3 in 4 Americans, including 84% of Democrats, 68% of Republicans, and 77% of independents, agreed that the appearance of wealthy donors or corporations gaining influence over or access to elected officials causes me to lose faith in this democracy. This is a crisis for our democracy, a loss of faith that goes across the political spectrum, and it has to do with the role of excess money in politics. That's what you're thinking of in S322. The U.S. Supreme Court opened the floodgates for unlimited, quote, independent expenditures and corporate cash in electoral process by striking down a federal campaign finance law regulating corporate electoral spending on grounds that the law violated the First Amendment. On that much, I agree with your legislative counsel. But the reasons why that case was decided, I'm going to get into. I disagree with the conclusions they've taken away from that case and some of the information that they didn't share in terms of what the court said and didn't say in that case. But anyways, because that case was decided on First Amendment grounds, many people, myself included, thought, okay, the only fix for this problem is to amend the United States Constitution to make it clear that legislators have the power to regulate corporate and political speech. And in fact, just 2 years after Citizens United, the General Assembly passed by tripartisan majorities, JRS 11, calling for such an amendment of the Constitution. Was 92-40 in the House, 26-3 in the Senate. But in the years since, experts in corporate and constitutional law have helped bring to light an alternative means to remedy the ill of unlimited corporate contributions that is plaguing our democratic process. And that means is clarified through the amendment of state corporate law, not campaign finance law, that the powers state corporate laws grant to corporations do not include the power of political speech. And this is important because corporations only have the powers that they are given by the general laws of the state. You may have a right to do something, but you don't have a right to do something if you don't have the power to do that in the first place. You can tell me I have the right to fly, but I don't have the power to fly. So I can't actually fly. S322 is that remedy. And it's a manner that is actually, in my view and the view of many other legal scholars, whose information is in the footnotes of my memo, is actually consistent with the US Constitution as it's currently written and as it's been interpreted by the US Supreme Court in Citizens United and many of the other related opinions that are in your Legislative Council memo. I'm not going to drill too deeply down into those cases because Tom Moore, who is really an expert in this, has put in a similarly lengthy legal analysis to the record. I'm going to touch on those later, but I want to get some highlights. By passing S322, the General Assembly would exercise its longstanding authority to define the powers available to artificial legal persons. And I think this is an important point. Corporations do have many of the same powers as human beings, but they are not themselves human beings. We as human beings are born with those powers. It's an inalienable right, what we are as human beings. Corporations don't exist until the state says they can exist, and it says what they can do in their existence. This authority predates the US Constitution and was thus reserved to the states like Vermont by the 10th Amendment of the United States Constitution. It rests on a bedrock principle, long honored by the US Supreme Court, that corporations and other business entities are creatures of state law and possess only those powers granted to them by the state laws that created them. So that section that Tucker put up, that covers that, what's in the Constitution. But I also want to point out what's in statute in terms of your implementation of Chapter 2, Section 69 of the Constitution that reserves to you the right to repeal or alter your general corporate charter laws. And that section says that any act creating, continuing, altering, or renewing a corporation or body politic, that's a municipality, may be repealed by the General Assembly as the public good requires. Emphasis. And any such act may be altered or amended by the General Assembly as the public good requires. In 2026, after you hear public opinion polling numbers like those that I recited at the beginning of this testimony regarding the extent to which the public has completely lost faith in our political process because of the role of corporate cash and independent expenditures, can there really be any serious question that the public good requires less corrupting corporate cash in our political process? Though S322 seeks to solve a problem Citizens United created, it actually doesn't conflict with Citizens United itself, nor other cases upon which Citizens United relies. And this is an important point because what Tucker said at the end of his testimony, and I don't know if it really sunk in for you, there is not a specific case on this issue. Citizens United dealt with a campaign finance statute. Citizens United also dealt with the assumption, as stated by Justice Scalia in that opinion, that the corporations before the court challenging the campaign finance statute were given the power of political speech in the broad charters they had under the state laws that created them. In other words, Citizens United assumed that the corporations before them had the power of political speech. And thus, because they had that power, their right to use that power couldn't be restricted. S322 is not about restricting a right. It is about removing a power. Vermont's current corporate laws contain the same kind of very broad grant of authority that Justice Scalia was referring to in Citizens United when he assumed that the corporations before the court in that case already had the power to engage in political speech. And this is what it says in our statutes. Every corporation has the same powers as an individual to do all things necessary and convenient to carry out its business affairs. So the way you've written our current corporate laws, your predecessors have, it basically says, yes, corporations, we've created you to do everything that a real live human being can do. But S32 is to clarify as no. When it comes to political speech and corrupting influence, there is a difference in the powers that real life human beings enjoy and those that are enjoyed by the artificial legal persons created by our statute. And Tom Moore is going to hit on this more, but there is no Supreme Court case, including Citizens United, that squarely holds that states like Vermont are prohibited from altering their corporate chartering laws to remove the power of political speech that's been assumed in that broad grant that I said to you before. And I emphasize assumed because it says necessary and convenient to carry out their business and affairs. Corporations aren't necessarily formed to influence politics. They're formed to make profit in the marketplace. So that's an important concept to remember as well. S322 thus is not fundamentally a campaign finance law restriction on corporate political speech. It is a repeal and alteration of corporate chartering laws upon which the claim to corporate political speech rights that Citizens United upheld rests. Okay? This would be a change in analysis that the court would have to engage in because unlike the corporations and Citizens United, you'd be saying, no, you are created without the power of political speech. Some have misread Citizens United as a vindication not of corporate rights of political speech, but of the rights of individual shareholders who come together to express their political views through jointly held resources in the corporation. That's a little bit of what Tim was mentioning before. But this argument, which was not actually the basis of the court's holding, it was just something they said in support of their underlying basis, which was based on a rights analysis, not a corporate powers analysis. But this argument ignores the reality that those individuals have other means to exercise their First Amendment free speech rights in the political process. So we're not taking away the right of individuals to assemble and pool their resources to speak on political issues in elections or ballot activity. Vermont campaign finance law that S322 would not interrupt already allows, quote, any one or more individuals, so a group of individuals, to accept contributions or make expenditures in any amount within any 2-year election cycle for the purpose of supporting or opposing candidates, influencing election, or advocating for or against the public question. Even if you enact S322, there would still be alternatives for individuals to associate, use their First Amendment freedom of association rights, and to use their human possessed rights to speak of political matters. Also, S322 will still allow corporations to engage in certain limited practices that were generally accepted prior to Citizens United and that don't genuinely undermine our political process in the way that unlimited corporate spend does. And examples include the ability to spend a de minimis amount on publicly announcing and endorsing a campaign. Some corporation wants to say, we endorse Senator Norris, he's been good for farming and our, farm. They can still say that. They can't go out and spend unlimited money money on ads to say that, but they can put that out there for anyone who cares what the view of, a corporation believes on that. And we'll allow that, this law will still allow them to say that. It also allows corporations to publicly lobby the legislature, because when you do a constitutional amendment, which you've done a couple of them recently, and there's others in consideration, you have to figure out what's the right wording for this. Well, some of those constitutional amendments might affect the corporate interest, and it's okay for them to come in and say, hey, if you word that constitutional amendment or a municipal charter change in this way, it's going to affect our business. If you word it in this way, it won't affect our business so much, or it will help our business. That's all been part of the political process before citizenship. That wouldn't change after S3. Now, at the last hearing on this, I know Senator Matos was concerned about legitimate business interests. You brought up the example of a print shop that somebody wants to have print up electoral flyers. You say, well, will that affect them? It's not prohibiting corporations or other artificial legal persons from accepting fair market value payments for performing a legitimate business service or selling a legitimate business good. It's not a contribution when somebody else is asking you to do it for fair market value, saying, hey, you're in the business of printing. I want to pay you your full rate to print up all these flyers that say Senator Matos for Senate. While S322 prohibits artificial legal persons from spending their corporate money to influence elections, it allows them to remain open for business when it comes to accepting the money of real human beings who are exercising their First Amendment speech rights in the electoral process. The plague of unlimited corporate money in elections is not a unique Vermont problem, but neither is Vermont immune from this plague. In our federal system, Vermont and sister states are empowered to enact laws that apply only in Vermont state elections and local elections. But if enough states like Vermont embrace their 10th Amendment authority to clarify that corporations chartered under their laws lack the power of political speech, the cure will begin to take hold and spread so that our political system can begin the long and long overdue process of healing itself. Vermont corporate law empowers members of this committee and your colleagues in the General Assembly to do what the public good requires when it comes to altering or repealing general corporate chartering laws. VPIRG urges you to advance the public good through passage of S22. Really appreciate your taking the time to hear me out on this. I do want to point out just a couple more things that my learned colleagues in Legislative Council says. I've never in my time lobbying here seen 3 Legislative Council working on one bill. So you're very fortunate with the brain power that they've decided to allocate to this issue. When Tucker was talking about dicta in the Bellotti case, I want you to understand what dicta means. It's basically a side comment. It's not binding on any future court. And the reason it's dicta in this case of Bellotti, not necessarily saying what S322 seeks to do can't be done, is because the court had no benefit of briefing on this topic before it made its decision. It wasn't educated in the difference between corporate powers and corporate rights. That wasn't a corporate powers case. It was a rights case. Colin Moore will emphasize the distinction a little bit more. So just to understand that is a difference. The other thing that you need to keep in mind, again, none of the corporate chartering Supreme Court cases that are referenced in Legislative Council's memos deal with the First Amendment. They deal with property rights, contract rights, in which third parties have reliance. Issues where the state would be taking something that the corporation owns, because corporations, clearly, it is an important part of their business to own assets. The courts have said you can't change the charter in a way that makes a corporation forfeit its assets or give those assets to states. And those make total sense. That is different than the First Amendment. And there's no case on that, on point on this. So while I respect the right of legislative counsel to make a prediction, I urge you to listen to my colleague Tom Moore, who's coming later and who will explain to you why, if the Supreme Court acted as the way legislative counsel predicted, they would be taking a radical step and a fundamental reorganization of the historical understanding of corporate law as being the province of the state rather than the federal government. So thanks again. I'm happy to take questions. I know you have a tight schedule, but I appreciate your careful attention to this.
Thank you. Committee, any questions?
President. Hope I have questions.
Okay, thank you so much.
Thank you.
Yeah, sure. Yeah.
You can keep it on live, but you just mute it. All right, we are back in Senate Judiciary. Took a few minutes of break, but stayed on live. We are pivoting to S-193. We have draft 5.1, March 12th. We have Ledge Counsel here with us, just to remind us of those changes and take a second. So, floor is yours.
Thank you, and good morning, everybody. Eric Patrick with the Office of Legislative Counsel, as the chair mentioned, here to talk with the committee for a few minutes about a new version of the proposed amendment to S-193, an act relating to establishing a forensic facility for certain criminal justice involved persons. We're on draft 5.1 of the proposed committee amendment to the bill. And as usual, you'll see the changes between this draft 5.1 and the previous one, 4.1, noted with yellow highlights. The first section of the bill having to do with the competency of restoration services. So in other words, the person who is transferred to the forensic facility on the basis of a finding of incompetency to stand trial. There are no changes in that section. So that's still the same as the version that the committee looked at last time. Same with section 2, actually. That's sort of separate idea. That's the idea that when a person has been found incompetent and the charges, the case has been inactive for a period of time, then it can be dismissed. That section is also changed. So the changes are all in section 3, which has to do with the NGRI, the not guilty by reason of insanity population. You'll see the first one on page 6. The way the process works in the bill is that when a person is found not guilty by reason of insanity for a sentence or crime with a potential lifetime sentence, that is part of the universe of people who are then transferred to the forensic facility. And there has to be a hearing held within within a certain period of time after they're transferred. So they're transferred there from the criminal division. They go to the forensic facility under the version of the bill that you had been looking at. This is page 6, line 13. That initial hearing had to be held within 40 days. So the proposal was to expedite that process. And the committee had suggested a 48-hour period so that once the person is transferred from the criminal court to the forensic facility, there has to be a hearing happen quite quickly in order to determine whether or not the person should still be confined there, which in other words, the standard is over on page 7. It states, slide 4, state's attorney establishes by clear and convincing evidence that the person is suffering from a qualifying condition that upon the person's release would create a substantial risk of bodily injury to the person. So that finding has to be, at least the hearing has to be held within 48 hours for the court to make that determination. So that's change number 1. I'm staying on page 7 where I just was. You see the next couple of changes. The first one, there's no substantive change in meaning here. The committee had noticed that the first sentence of subsection C really certainly was not legally necessary to include that sentence. So it's rewritten without that sentence just to say that a person committed to the forensic facility pursuant to this section shall not be released until the court finds, and it's the same standard that I just read to you from above, because this is a standard that applies throughout the proceeding. So a person stays there until the court finds that they're no longer suffering from that qualifying condition that upon the release would create the substantial risk of bodily injury. So another person.
Eric, I think this is my fault. I didn't clarify this. My goal was to have the court taking into account the least restrictive conditions applicable, not the commissioner of corrections, and determining if somebody's going to be is going to remain committed. Is that we make that change, or does it? What are your thoughts on that impact?
That seems unusual to try and figure out how that's going to apply to the standard. The decisional standard throughout the bill is substantial risk of bodily injury to another person. That's whether or not the person should be there, not what the least restrictive means are once they're there, or the different criteria, in other words. So that's can be rewritten that way, but it's different.
How? Remind me how we have it for competency restoration?
Yes, that is back on,
Oh, I see. Yeah.
it's the, page 2, line 12 to 16. And it has to do with whether, it's a restoration process specifically. Court orders impeding commitment, unless, the find that they can be. And it sort of fits there because that's the idea that the court is making a decision about whether or not the person can be released into the community or not, or whether they should stay at the facility. It's not the initial determination of whether the person should be there, but then, so this is in context of a later about a subsequent evaluation.
Yeah, I get it. I see. Okay, no, it makes more sense now. The way it is for the NGRIs also matches with what I'm seeing in the Olmsted decision. So that's, yeah, that works.
Yes, I reviewed that case as well. I think this proposal arguably fits within the decision.
Okay. Great. Anything else?
One thing I noticed, just to echo, page 7, lines 18 to 19. I don't know how that's slipped through, but that's the serious property damage. Remember, the committee had removed that because for some reason. I looked at it too many times, but didn't catch that. So why don't you strike those words on lines 18 to 19?
So if we, okay. Drop that up as a scrivener's error, right?
Yeah.
Okay. So are we, the committee, any questions or comments on these? So if we just strike or serious damage to the property of another person, is everybody ready to vote on this bill?
Yes.
Yeah.
So Eric, do we need a new copy or anything, or can we just say that we're going to vote on 5.1?
You can say 5.1, yeah.
And that will be removed for the version.
Yes. Yeah, 100%. It does still, I'm gonna go through editing one more time, but yeah, those would just be grammatical corrections, that sort of thing.
Okay. And just one point to raise is, voting this out today, the Health and Welfare Committee is also taking additional testimony tomorrow, and they were able to get both the WellPath to come in. So they'll be, my understanding at the moment, it's their intent to provide an amendment that increases the focus on the medical care, which is excellent. So we'll be expecting that. So voted out, it'll be held on the calendar for a little bit as they get their amendment ready, and then we'll hear that amendment.
I'm sorry, my day yesterday got a little bit away from me, so I didn't get a chance to follow up with you about liability. But in an instance where there are lawsuits pending against, in this instance, WellPath, and they're contracted with the state, if WellPath files for bankruptcy and shields themselves from liability, does that put more liability on the state to deal with those claims? My understanding is that is what happened in Massachusetts. And so I'm wondering if something similar could unfold where the state is now liable for negligence on behalf of our contracted provider because they are in Chapter 11 proceedings, which they currently are.
I don't know about the impact of bankruptcy necessarily, but it is true that when the state contracts with entities to provide state functions, that is not a way generally for the state to get out of liability. So generally speaking, it's happened in the corrections context before, with private prisons, that sort of thing. That exact issue has come up, but it's happened in a number of contexts. And there's a test that the court uses. It's, essentially a state actor, that sort of thing. But
in the instance that WellPath couldn't pay for those claims, it would be on the state to pay them.
I'm just not enough
Okay.
familiar with the bankruptcy elements of that to give you
Okay.
a good answer. But I think with that point aside, yes, the person that the entity's a state actor, state can't get away from liability.
Thank you.
And I would entertain a motion to vote this out favorably. Is there a second? That is, you know, record that.
Yeah, absolutely.
Need all of us there.
There you go.
All right.
Any discussion?
Senator Norris.
Yes.
Senator Brew.
Yes.
Senator Meadows, yes. Senator Vigilski.
No,
Senator Machine. Yes. 4-1-0.
I'll put it in. So. So we want to have it on the calendar, but do I take it up?
We can pass over.
Pass it, right, if we need to, just want to make sure.
Yeah, I would take it up now and then, we could go on. Above first time on.
And I can you pass over?
So I'll have, the proofers, just get a great copy
Yeah.
right now. So it'll be
Like
a little bit, like this is gonna have to lunch at some point, but I'll send it to every CC, so you know it's got motion on it. Is that right?
Perfect, thank you.
Yeah.
All right, we can take a 10-minute break. We have Tom Moore at 11:30.
We're taking a break until.
Yep, 10-minute break. We can go offline.
What are we doing then?
Follow up with a witness from this morning.